welcome to this morning's event, which the Fingal Chamber are running in conjunction with our partners, Adare HR Management. I'd like to welcome Sarah Fagan here this morning, the Managing Director, to talk us through some of our findings. And I think we've got sort of the next 45 minutes or so boxed off for this. So, Sarah, if I can hand over to you.
Thank you so much, Anthony, and it's great to be here today, in particular as we look to really kind of focus in on what's happened from a HR and employment law over the course of the last 12 months, as well as what businesses within the Fingal Chamber membership need to, I suppose, take note of and look forward to in terms of their planning as we approach 2023. In terms of today's session, I really just wanted to reflect on the other macro influencers that organizations are really taking account of now as they enter into their planning for 2023. So for today's session, there is a lot of content. So I will be moving at pace, but do feel free to put in any questions you may have into the chat function, and we'll try and keep some time at the end to answer any questions you may have. I want to touch on some of the HR priorities, metrics, pay and benefits data that's coming from our most recent HR barometer report, as it really does set the scene in terms of the compliance side of things and what organizations need to consider as we move into 2023 before reflecting back on the last 12 months as to the changes that have been applied, making sure that you're all compliant in that regard and have considerations of what is coming up in the coming year. In particular, as we know, the government have announced that they will be publishing the right to request remote working legislation in the coming weeks. So we are anticipating that to be out in the coming weeks, and it's something that we really do need to focus in on. So there's some time set aside today to look at what it may look like and what the government are saying in that regard. So just taking stock of what's happened over the course of the last 12 months, obviously, I think we could have all anticipated some rise in inflation coming out of a pandemic, but certainly not to the extent that it did. And it was unprecedented in terms of the rising and high inflation that we've seen over the course of the last 12 months. And certainly, it has sort of tempered employee expectations when it has come to salaries and total reward, which has put additional challenges, I would say, on employers as well. Notwithstanding the fact that we're at, really high employment within the country, there still has been, because of the buoyant employment market, a number of challenges that have arisen from recruitment, talent acquisition, and skill shortage. So certainly when we're considering the impact of the external or macro influencers such as inflation and the salary expectations that have come with it, it hasn't made it any easier for businesses within Dublin and the Fingal region in terms of resourcing and seeking to retain key talent as well. And what we have seen from our HR barometer report, which is a national survey, is the fact that organizations are looking to the medium and long term. So there's some quiet optimism, notwithstanding that there's still talks of a recession. Economists in Ireland are more quietly optimistic as opposed to their international counterparts, but it certainly is pointing to a more employee-centric sort of vision for the medium to long-term success of your business and goals. And with that, we identified some of the key HR priorities. And certainly it would be no surprise that retention, recruitment, and talent acquisition are coming in as the top priorities, and followed closely by employee engagement. Why this is important is because we're all in the course of planning for 2023 and looking at that longer term investment. It's really important that organizations are strategically addressing these areas to move away from the reactionary that we've had to be over the course of the last 12 months or even 24 months because of the challenges that have arisen. But certainly in ensuring your value proposition as an employer is front and center in terms of how you strategically address these situations. Excuse me. And from a HR metrics perspective, we also look to understand what the expected average employee turnover is likely to be in 2023. And it has come down quite significantly to 13.6% expected employee turnover, which indicates again some return of confidence in businesses in terms of what they're anticipating. Because if you recall, over the last year or so, employee turnover had risen quite high to 18%. So certainly when we're looking at that potential decrease in the next year, it's important to understand, okay, what else can we do as a business, not alone just addressing the compliance situations that have arisen with all the employment legislative updates, but also looking to ensure you're strategically investing in the employee journey to eventually sort of invest in your overall ambitions as a company. In terms of talent acquisition, again, I think it's really important that organizations look to understand what they're doing for the next year. Excuse me. So 63% of organizations are increasing headcount in 2023. Again, this is positive, and there's a HR employee to fixed term employee ratio of 1 to 64. So 1 HR employee to every 64 employees, which again shows a confidence in the market on the basis that there has been a slight increase from our last HR barometer report. And certainly from a planning perspective, it just demonstrates what you need to do to strategically attract key talent to your organizations to ensure that you are workforce planning and succession planning, because all of those will invest in the employee journey and create a better value proposition for you as an employer. What we have seen in terms of learning and development, and when we ask a key question in terms of investment, is that 54% of organizations are increasing spend in learning and development for the next year. Why this is important is because we look to understand, what are the shifts and the trends in terms of organizations and businesses within the region. And certainly, coming in at 9.6% is the percentage of overall payroll, which represents the average investment in learning and development in the next year. Again, this is just demonstrating the employee centricity of the strategic HR that essentially will assist you as an organization in retaining your key talent, as well as attracting key talent to your organization. And essentially, when you're putting your value proposition front and center from an employer's perspective, it's really about honing in on these things, the things that assist you in differentiating yourself from your competitors to attract that key talent. And essentially, it means that we've broken it down into what that looks like from a day perspective. So there's 6 days on average. It's the number of days per employee allocated to learning and development in 2023. And this is extremely positive. And again, I think it demonstrates the optimism within the market, notwithstanding that we've had a myriad of challenges in relation to an international pandemic, as well as the energy crisis, rising inflation, etc. But now organizations are shifting their focus to look at the medium to long term and truly bring their value proposition front and center in order to attract the key talent. And all of this is obviously, done in innovative ways. And because of the shift in working practices, we've seen just a third of those surveys really ensuring that they are delivering innovative L&D courses and so forth online to accommodate the changing working practices. And 56% of organizations implemented new learning and development initiatives in 2022, excuse me, which also demonstrates that we need to consistently look at this as a value proposition method, because with the changing employment legislation, there's greater financial liability that is coming down the road for organizations. So investing in your employee journey to ensure that you're retaining that key talent is really important as we move into 2023. From a pay and benefits perspective, 67% of organizations are increasing or have increased salaries in 2022. And throughout the course of the last number of years, we've seen that move between 3 and 4%. But more recently, in April of this year, when we had surveyed participants, they were anticipating an average increase of 5.3%, which again was far in excess of what had been the range over the course of a number of years. But the actual increase being applied this year on average from our survey participants is 4.80%. And that again demonstrates that there's been a leveling off of the market, notwithstanding the buoyancy of the employment market, the challenges for recruitment and retention. Effectively, organizations are looking to ensure that it's all about sustainability as we move forward. And that's something that's extremely important by virtue of the fact that there could be increases to expectations on salary increases in 2023, as you see in front of you on the slide. And certainly what we have seen as well that demonstrates the leveling off of the market, but also the balance that is coming in from an employee expectations perspective is that any increases are now going back to company affordability, company profitability. 6 months earlier this year, we had seen an increase in unconditional increases being applied for salary increases, which was at 31%. That has now reduced down to 13%, which again shows the confidence within the market, but also, as I mentioned, the sustainability factor, which is extremely important as we consider the potential financial implications that are coming in because of the employment law updates. The government have quite strongly come out in terms of their national remote working strategy. So we're going to look at what that may look like from a legislative point of view and what you can anticipate in the coming weeks. But it's always important that we do reflect back on what has happened over the course of the last 12 months. In particular, if you haven't had an opportunity to communicate these changes with your employees, to update your policies and procedures, and to ensure that you are fully compliant as we, still are experiencing challenges when it comes to an employee relations perspective or indeed industrial relations. So the first thing is obviously the Gender Pay Gap Information Act 2021, And essentially we saw in June the government effectively commence that order in terms of the legislation. So organizations with 250 or more from a headcount perspective had to take a snapshot of their gender pay gap information in June, and again are expected to do it in December to essentially then publicize that information on their website. Now, for organizations of 150 or more employees, the expectation that you're doing that does not arise until 2024 and 2025 for organizations with 50 or more headcount. And essentially, employers are going to have to continue to do this once they fit into those headcount perspectives. Well, what I would say is that what we are noticing is a lot of organizations who are not legally required to actually report on the gender pay gap, they are currently doing that from a voluntary perspective. And this is essentially really good practice because we have seen challenges for organizations as they're trying to gather and analyze that information to ensure that they are being compliant with the legislation. So there's one aspect of it that you're preparing for the legal requirement and ensuring that you're applying it in the correct way. But the other way to look at it is effectively that if you're doing it from a voluntary perspective, and there are a growing number of organizations that are doing that, it is something that you can use to your benefit, depending on the results, of course, in relation to attracting key talent to your organization. It is something that must factor into your value proposition, as I was mentioning earlier. So in the sense, if you're preparing for it in advance of the legal requirement for your organization to do it, you are effectively putting into practice something that will assist you in retaining talent as well as attracting talent. But in terms of the current legislation for those organizations with 250 more, we're going to start to see over the coming month a lot of information being publicized within organizations of that size to outline the details relating to the mean and the median gap in hourly and bonus pay between men and women. And that applies as well for part-time and temporary male and female employees, as well as those who receive bonus pay and benefits in kind, and ensuring that the proportions of male and female employees are identified, whether that's in the lower middle, or upper middle and upper quartile pay bands. And essentially, the purpose of this legislation is really to hone in on what that gap is, when we consider that the European or even national average currently is just over 14%, you would like to anticipate that as an organization, you're coming in below that. We have seen over the course of the last, I would say, 6 months, some organizations that have come out to say that they're at 0% within Ireland. And that was publicised in the public arena. And it actually does, quite a lot from a reputational perspective in ensuring that you're retaining your talent as well as attracting key talent into your organization. But in the event that there is a gap that does exist, essentially the obligation on employers is to really identify, in their opinion, the reasons for such differences, and where a gap does exist, the measures, if any, being taken or proposed to be taken by the employer to eliminate or reduce such differences in that employer's case. And essentially that is, the compliance requirements from a legislative point of view, but it does mean that there will be a sharper focus by organizations in ensuring that they are compliant with that as they take their snapshots. Now, another significant change that came in March of this year related to harassment and sexual harassment. And essentially the IHREC, so Irish Human Rights Commission, publicised a new code of practice, or an updated code of practice, in relation to harassment and sexual harassment. And there was a lot of differences between this, the newer code of practice and the previous one, placing additional obligations on employers to ensure that they're implementing sufficient preventative measures within their organizations to ensure that they're supporting an environment, a workplace that is free from harassment and sexual harassment. So what they have indicated within the code of practice itself is that there should be an appointment of a designated person, somebody who officially is named within the organization, has received the appropriate training and so forth, and has the skills and experience in managing and dealing complaints of this nature. Now, the purpose of this role is to either facilitate a resolution at the informal stage, or to point to the parties involved in a complaint, the approach that can be taken in relation to the policy and procedure within the organization and so forth. They've also recommended a new, what they're terming, senior level champion. And, they have outlined that this could be dependent on resources. So it could be, more appropriate for organizations of a bigger size to effectively have this in place. And certainly this role is important in that they should be advocating, for different initiatives, innovative practices when it comes to preventative measures in relation to harassment or sexual harassment, and ensuring that training is consistently rolled out to all employees. Another interesting point that was outlined within the code of practice is the fact that they've recommended an investigation panel that is gender balanced. Now, this is something that for some organizations they would already have had in place, but essentially it hasn't been contained in the previous code of practice. And for some organizations, they will have the resources to provide this investigative panel that is gender balanced, but that may not necessarily be the case for all organizations. And that's something that the code refers to, that it could be resource dependent. But there is a huge emphasis on the requirement of awareness raising initiatives, training and competent and skilled managers to deal with the issues. And that's something that they previously hadn't called out in relation to the skills and the experience that are required from an investigator's point of view, or somebody within the organization who has been appointed as the investigator, to ensure that they are adequately trained and able to manage that investigation. And essentially, there has to be an overcommitment, almost essentially, in regularly reviewing the policy and procedure by a competent person with the appropriate qualifications, training, and experience. And within the realms of this code of practice, essentially, you need to ensure that your current policy and procedure has been updated to reflect the best practice and guidelines that are recommended and outlined in that code of practice. Now, at the same time, the IHREC also issued a code of practice on equal pay. And the purpose of this code was to promote the development and implementation of procedures that establish workplaces where employees receive equal pay for like work. And the code aims to give practical guidance to employers, employees, organizations, trade unions on the right to equal pay, the elimination of pay inequality, and the resolution of pay disputes. So certainly within the code of practice itself, it's really about ensuring that there is fairness, equality, and transparency when it comes to any of your remuneration models. And this is something that a lot of organizations already have a policy that's reflective of that type of practice under their dignity of work section from an equal opportunities perspective, that they would apply equal opportunities in all areas such as recruitment, pay reviews and so forth. But it's something that the IHREC have outlined within the code of practice that this should be front and center. So it is recommended again that if you don't have a policy that's discussing equal opportunities, you certainly should develop it, and you can get guidance from this particular code of practice. So notwithstanding that these were issued a number of months ago, there are still organizations that need to reflect and review on their current policies and procedures. They may have to communicate those with employees, provide appropriate training and so forth. And that is something that should be done as soon as possible if it hasn't been already. In terms of the legislative updates, as you know, there's been so much talk in relation to the Statutory Sick Leave Act, and effectively a commencement order has been provided by the government or the minister of January 1st for the provision of paid sick leave to employees. Now, within the scheme itself, they have set out that effectively the purpose of it is to ensure that the existing gap that's caused by illness benefit waiting days, so effectively on day 4, where employees can avail or apply for illness benefit from the Department of Social Protection, that the purpose of the legislation is to fill that gap and set a minimum form of entitlement for employees who are unable to work due to illness or injury. So the benefit outlined from January 1st, 2023 is that 3 days paid sick leave must be paid by employers to employees who are effectively ill or injured from that date. Now, the rate of payment will either be 70% of normal wages that has to be paid by the employers, but that's up to a maximum of €110 per day. They have set out as well a number of criteria in terms of employees being able to avail of it, one of which is the provision of a medical cert from a registered medical professional. And this must be done for either each consecutive day or individually as the days arise from the start of the year. And all employees, in order to be able to avail of statutory sick pay, must be in employment for a continuous period of 13 weeks. And effectively, employees cannot be penalised for exercising their right to avail of statutory sick pay, and they have the right to complain to the WRC where they are not provided with the company's sick pay scheme and effectively are trying to apply for the statutory sick leave. Now, the legislation itself outlines that the minister does have powers to increase the number of days. So whilst, the increase of days from 3 days to 5 days to 7 days and so forth is staggered over the course of a number of years, the legislation does provide for the fact that the minister could increase it at any time. But once an increase is made, so say, for example, within 12 months' time following the enactment of this, the minister decides that he's going to increase the amount of days, a change cannot be made till 12 months after that, after he intimated there is a change or increase to the days. Now, this may not necessarily happen, but I think organizations need to really start planning from a financial and budgetary perspective what they're going to do, what the anticipated sick leave may be, so that they are factoring that into their budget planning. But essentially, they have outlined within the legislation itself that it may not be possible for employers to actually pay that from a financial perspective. And we are awaiting further clarity from the Labour Court, but an exemption from the obligation to pay where the employer is deemed unable to pay by the Labour Court can and will happen. But we need further clarification as to how this process will apply. Currently, it outlines within the legislation that if an employer is seeking to apply for an exemption, that they have to get an agreement from the employees within the organization that they agree the employer must go to the Labour Court because he or she hasn't got the financial means to make payment for statutory sick leave. But again, I would imagine in the coming weeks, we'll start to see a greater shape on what that process looks like. And certainly we'll ensure that we do issue out communications through the Chamber to all members when that occurs. But a lot of instances will arise where organizations have a more favorable company scheme in place when it comes to sick pay. And in that regard, where you can demonstrate that it is more favorable in every aspect, then you don't need to obligate yourself to the requirements under the legislation, because there will be a more favorable sick payment to employees regardless. But the main thing is that a lot of organizations have discretionary sick pay in place at the moment. And it's, to give you one example, some organizations might provide for discretionary sick pay, or a sick pay in the amount of 2, 3, 4 weeks and so forth over the course of a 12-month period. But there might be stipulations within your current policy that outline sick pay is only payable following successful completion of a probationary period. So in that case, you need to ensure that you are amending your policy appropriately to account for the statutory sick leave element that you will have to provide to employees where they're with you or employed by the organization for a continuous period of 13 weeks. And you'll have to separate that out from your own occupational sick pay scheme. So, policies are going to start to become a little bit complicated depending on the parameters of your current scheme that are in place. But in any requirement where statutory sick pay is being made by an organization or an employer, you need to ensure that you maintain records for a period of 4 years. And this is because inspectors can, from the WRC or even the Health and Safety Authority, effectively, visit your site and look to establish, are there records in place that demonstrate compliance with the legislation where an employee has availed of statutory sick pay. So a few considerations going into 2023. Now is the time to update and review your policies so that you are effectively rolling it out from January 1st. Now, another area, a significant area that actually updated this year more recently in the last few months was the Protected Disclosures Amendment Legislation 2022. And effectively, the changes that will impact organizations in this regard is the fact that they've expanded the scope of protection by extending the definition of worker, which now includes board members, including non-executive members, shareholders, trainees, job applicants, and volunteers. So by the expansion of that scope, effectively, it's widening or broadening the potential of an organization receiving a protected disclosure. And they've also defined the relevant wrongdoing by extending it to include a breach which includes an act or omission that is unlawful that relates to financial services, anti-money laundering, and terrorist financing, public health, and consumer protection. And effectively, they have outlined that from December 2023, employers with more than 50 employees, but less than 250 employees, are required to establish internal reporting channels, and that for those with 250 or more, must have them in place from publication of the Act. And essentially, I would say that a lot of organizations already have a protected disclosures or whistleblowing policy in place that outlines what those internal reporting channels are. But what you need to do is review your policy and procedure to ensure that the expanded scope of the definition of worker and relevant wrongdoing is being captured within your policy and procedure. And this is something that you're communicating with all employees that you have to ensure that they're versed on what those changes mean and give an opportunity to put any questions to you. But in terms of the Amendment Act, they've also outlined different requirements for those who receive a protected disclosure, and those are more time-bound in terms of acknowledging receipt of the protected disclosure within 7 days, diligently following up on the information contained in the protected disclosure, providing feedback to the reporting person, and that is within 3 months following the initial assessment, and communicating to the whistleblower the final outcome of the investigation that was triggered by the protected disclosure. And with the broadening of the definition of worker and relevant wrongdoing, they've also broadened the definition of penalisation to include direct or indirect penalisation. And effectively, protected disclosures, when they are made, they are often more complex. It's not necessarily cut and dry in terms of the length of time that it'll take to investigate. And, with that complexity means that there's a lot of burden and onus on an employer to ensure that they are fully compliant with the legislation, in particular because of the updates that are now applying within this act. And in the event that, for example, if an employee who maybe made a protected disclosure was dismissed, could be for an entirely different reason, effectively the burden of proof sits on you at the WRC to discharge the fact that you have done everything, that you didn't penalise this employee, that it was a potential separate and distinct process which actually led to a dismissal. And that's just to give you an example. But the reason that you need to really ensure that you're fully compliant in everything that you do, in particular anything that is distinct in dealing with an employee who has brought a protected disclosure, is because the financial liability is actually quite significant. And it is an offence to for a failure of an employer to operate internal reporting channels or to penalise an employee. And it could attract fines between 75,000 and 250,000, which is really significant. And also the offences could include imprisonment of up to 2 years. So certainly when you consider the broadening of the scope of the definition of the worker, the fact that it now can include non-executive directors of a board, it can include volunteers, candidates from a recruitment perspective, etc. And the fact that it's broadened the scope of the relevant wrongdoing and penalisation, you have to be very compliant when it comes to dealing with anything under this heading. So please do ensure that you're now taking it upon yourself, if you haven't done so already, to review your policy and procedure. If you haven't got one in place, the time is now, and the legislation is quite detailed in terms of what should be contained within that policy and procedure, or ensure that your HR provider is providing you with that fully compliant advice as to how it should be drafted and how it should be developed and rolled out and so forth. Other changes relate to, and this is upcoming changes, relate to the general scheme of work-life balance and miscellaneous provisions bill. Now, I will speak to a connection regarding this now with the right to request for remote working in a moment. But first of all, just to detail what this EU directive essentially means for employers within Ireland. Essentially, the purpose of it is to achieve a better work-life balance for parents and carers. And that will include a right to request flexible working arrangements for a set period of time for caring purposes. And it applies to employees with children of up to the age of 12 or 16 if the child has a disability or long-term illness, and employees with caring responsibility. And effectively, what this EU directive has outlined is the provision of 5 days unpaid leave per year per employee, where for serious medical reasons, the employee is required to provide personal care or support to family members. It also makes a provision for the extension of the right to pay time off or work or reduction of working hours for breastfeeding purposes, and extending that period from 26 weeks to 104 weeks, which again is quite significant. And you may have facility within your organization to provide a private area for an employee who's availing of this, but it's also ensuring that if you don't, you're making provision for them to get paid time off work where it's required, and that's now extended or will be extended from 26 to 104 weeks. And also the final provision is a right to 5 days per year paid leave for victims of domestic violence. And this is something that's been highly publicized, and it's going to be a huge benefit as an organization to be able to make this provision for employees who are in a very difficult or challenging area within their lives. Now, the reason why I'm just going to move straight to the right to request remote working is the fact that the government are about to, in the coming weeks, publish a finalized version of the legislation that will be enacted. And essentially, earlier this year, or even at the end of 2021, we saw the heads of bill, which outlined a number of requirements when it came to the application process of requesting remote working. Now, a lot of you might say, well, look, we actually have a remote working policy or a hybrid working policy in place, so we're okay. And effectively, for the main, I'm sure you are, but the legislative right that will be enshrined or enacted will detail an individual's right to request remote working, which could completely vary from what you have in place already. So to give an example, if you have a hybrid working practice and policy, which outlines perhaps a day or two anchor days within the week that a person needs to be in the office and the rest can be done remotely, an employee could apply for 5 days of fully remote work, and that's something that has to be considered under the legislation. I'm not going to go into a lot of detail. Suffice to say that they're saying there has to be a 26-week service requirement for an employee to make that application, and an employer has to respond within 12 weeks, and that in the application there is a self-assessment in terms of, from a health and safety perspective, their setup at home, as well as consideration regarding how they're going to operate, and considerations for the business. But essentially, what was contained in the original heads of bill was an outline that an organization had a number of categories to which they could refuse the right to request remote working. And there was a lot of uproar, both from employer groups and employee groups, in relation to how this was detailed within the heads of bill. So the government have met with representative groups over the course of the last 6 months, and effectively they have intimated that there's significant changes to the heads of bill. So whilst we imagine that there will still be an appeal available to the WRC, there will still be an anti-penalisation provision, and the potential reward from the WRC could be the same. It may change. The fact is that the business justifications for refusing a right to request remote working could lay significant challenge on an employer. And that's something that we're looking to view once the legislation has been enacted. And certainly in regards to the government itself, what they have outlined, or Leo Varadkar outlined, I believe it was 2 or 3 weeks ago, is the fact that when it comes to the right to request remote working, as well as the work-life balance EU directive, they intend to integrate those requirements into one piece of legislation. So effectively, it means that employers and employees will now be making and considering requests for remote working under one piece of legislation and under one code of practice. And under the integrated bill, the grounds for refusal will be replaced by an obligation on the employer to consider both the needs of the business as well as the needs of employees when it's assessing any request. And employers will be required to ensure that they're compliant or aligned to the code of practice when considering requests. So that is going to impact on how you develop a policy and procedure, which could be distinct to your other policy and procedure that you have in place right now, that's currently applying hybrid, perhaps remote working requirements of your business. But you will need to ensure now that you're guided by that code of practice to effectively be able to demonstrate, if it were to go to a third party, that you are compliant and that you followed whatever process is outlined within the new integrated bill. And essentially, a complaint regarding non-compliance can be brought to the WRC. So this is seen as an enhanced right from the current heads of bill on the right to request for remote working. So we need to understand, and we will only get to understand once the legislation is enacted, or that we see further details on the integrated bill, what that potentially could look like. But essentially, the integrated bill has outlined that remote working will be defined as one type of flexible working, and the right to request any other type of flexible working, such as reduced hours, will be limited to the parents and carers, and that's bringing in the work-life balance aspect of the EU directive, and that will be defined in the bill. So there's a lot to, I suppose, look out for over the next week or two. And certainly it's something from a planning perspective, the earlier we get sight of that integrated bill, the better, to ensure that, from January 2023, organizations are prepared to apply any changes that they need to their policies and procedures. Now, just in relation to other EU directives that the government are currently looking to transpose into Irish legislation, we have the Transparent and Predictable Working Conditions EU directive. Now, this has outlined a number of key provisions, some of which you could say are already contained within Irish employment legislation, but some where they will have to make amendments to legislation. Interestingly, they have addressed probationary periods and have outlined within the EU directive that those should be limited to 6 months, which would be proportionate for fixed term contracts. And any extension to 6 months must only apply due to the employee being on leave. Now, effectively, I'm interested to see how this will look as it is contained in the legislation, because we all know from a HR perspective, it can be best practice, depending on the circumstances, in terms of managing an employee who's on probationary period, to extend that probationary period beyond what would ordinarily be seen as a 6 month standard, that you may extend it for 7, 8, or 9 months to ensure that the employee has been given sufficient opportunity and supports to, thoroughly engage in the work that he or she was employed for. So limiting that requirement in the EU directive and outlining that it can only apply to an employee being on leave, which would happen regardless, may cause some challenges. But again, we need to wait to see how this is written into legislation to really ensure that those are the changes that will be applied by the Irish government once they transpose the EU directive. Also contained within this directive is exclusivity of service, which is common to have in contracts of employment. And I would imagine a number of people on today's webinar would actually have those as standard clauses within your contracts of employment. But within this directive, they have outlined that an employer cannot prevent an employee from working with another employer, but that certain limitations may be possible. Now, again, we have to wait for the legislation on this, but I would imagine these limitations will have to relate to some form of, exclusivity being able to be maintained in terms of somebody who's trying to work for a competitor, or where, trying to bring clients across to one of their competitors if they are terminated in whatever way, voluntary or otherwise, within your own organization. But again, it's one to watch out for, because we need to see how it's written into legislation. And then finally, it has outlined unpredictable work patterns. And I suppose this is the element which I would consider is currently legislated on. But again, we might see some amendments to the employment miscellaneous provisions legislation, which, if you recall, outlined the requirement, to provide 5 core terms in relation to employment within 5 days. And it was the ban on 0 hours contract. So that may be amended to accommodate what is contained within this EU directive. But what they have outlined within the directive itself is that an employee cannot be required to work unless information on hours, days, and notice given to that employee. And if work is cancelled, that they must be compensated where reasonable notice has not been provided, and that an employee can request more predictable and secure working conditions. So as you all know, with the outlawing of 0 hours contract, this is something that technically is provided for, but again, they're trying to ensure compliance with the EU directive. So we might see some changes coming down the line in relation to that. Now, the final piece of legislation, and then I might hand back to Anthony to see if we have any questions, relates to the Payment of Wages Amendment Tips and Gratuities Act 2022. And essentially, this is something that became effective on December 1st. A lot of organizations, actually all organizations, wouldn't have had a policy and procedure in place prior to the enactment of this piece of legislation, on the basis that it's new, and the key provisions effectively require employers not to use tips to make up an employee's basic wage, and prohibits employers from deducting from an employee's wage in respect of tips and gratuities made to an employee. And that effectively organizations within the hospitality sector, and they have a number of different categories outlined in the legislation itself that you should review to understand if you are considered to be part of this, but that effectively you do have to clearly display your policy on tips and gratuities so that your customers effectively are fully aware of how tips and gratuities are being distributed amongst the staff, and that you cannot use the term service charge or similar unless that gratuity for the service charge goes directly to staff. And they have outlined that both tips, gratuities, service charge, etc., are seen as voluntary payments. So it's something that, within a policy that now has to be displayed for your customers, you need to ensure that you're outlining how that is being applied to staff. And if it's not being applied to staff, effectively it's illegal and you're non-compliant with the legislation. And a situation will probably often arise within that sector where an employer might perform the same work as a staff member. And in that regard, they may keep a share of the electronic tips, but no more than an amount that is fair and reasonable in the circumstances, considering that there should be equality and transparency when it comes to that. It should be the same proportion as all employees. But failure to adhere to specific obligations under this piece of legislation could make you liable under summary conviction to a Class C fine up to a maximum of 2,500. And also, I would imagine, have significant impact in terms of PR implications for your business. So it is something that you need to ensure that you are providing. Finally, and then I will stop and hand back over to Anthony. Whilst we're awaiting legislation, I just wanted to mention, obviously, I'm assuming a lot of you would have heard already the government's announcement in relation to reforming of the state pension scheme, and that key provisions relating to that is to maintain the state pension age at 66, but introduce a new flexible pension age model. And the option will become available from 2024 for employees to continue working up until the age of 70 in return for a higher state pension, and that there will be a move fully to total contributions approach for calculation of individual pension entitlements on a phased basis over 10 years. And that as well will be from January 24, and the enhanced state pension provision for long-term carers will be introduced in 2024 as well. So again, that's something that we'll have to wait and see how that is shaped within legislation. But the one thing that I would outline is that currently you would have a contractual retirement age, most likely in your contracts of employment, and effectively there is no legal status when it comes to retirement age, but there is a code of practice on longer working that places increasing obligations on an employer to objectively justify why you would refuse to allow somebody to remain in employment beyond the retirement age. And that can be very challenging, and it has huge employment equality repercussions. And we've seen some huge cases over the last number of years where the financial liability has been in the hundreds of thousands, where this was not demonstrated by an organization. And I think one consideration that I will leave you with relates to the increase of the option to work up until the age of 70 may have ramifications for that code of practice, but also your own practice and policy in relation to contractual retirement ages. And that's something that you may have to factor into your planning, not necessarily now or in the upcoming year, but in the years to come, to ensure that you're considering it. It is very, it can be seen as very opportunistic as well from a diversity, equality and inclusion perspective, something which, you know, will help with your value proposition as an employer, but it's all about the balance of rights to employees and between employees and employers. So those are, I suppose, the final considerations that I will leave you with. So I'm happy to open the floor to any questions if anyone has anything in particular. Anthony, I don't know if there's anything that you thought of as I was going through those changes, the ones that have happened and the ones yet to come.
Sarah, hello.
Yeah, sorry, did I?
Screen froze here now for seconds.
Okay.
Just saying my internet connection is unstable. But anyway, yeah, no, thank you for that, Sarah. It was extremely comprehensive, which, you know, when you look at this and you see how complex that employee, like legislation is today for the employer and the employee, it's fantastic to have the support and the expertise of Adare Human Resource Management as working with us as a Chamber of Commerce. There's a couple of questions here.
Yeah.
How long does an employee have to submit how long does the employee have to submit their sick cert with the new legislation? So that's, I'm sure, is in relation
to. So, and I think this is where like a complication arises, because some organizations already have, you know, an occupational or company sick pay scheme. But if you are affording an employee, which will be their right, their entitlement to statutory sick leave, that medical cert on the first day of absence, where you're paying them statutory sick leave, will have to be provided on that day. Now, it may be a case that a reasonable employer will say, well, if you're out on day one and I'm paying you statutory sick leave, you know, up to €110, I'll accept it the next day because you're physically not going to be in the workplace. That is reasonable and that's fine. But the obligation on the employee is to ensure they have that cert from day one.
Okay. The sick leave, staying with the subject of sick leave.
Yeah.
3 days, consecutive days, or 3 individual days. So is it 3 in a row, or is it one this month, one next month, and one the month after?
No, it can be either. What they've said is 3 days in a year. Now, interestingly, you know, when we review legislation, we always look to the definitions that are outlined within the organization or within the legislation, sorry, and they haven't defined if it's a calendar year. But we can make assumptions that it is, but those 3 days can be taken individually or consecutively within a year. And in that regard, payment will have to be made by an employer to an employee.
Okay. And we've actually it's a very good question actually here. Given that it's quite difficult to get an appointment for a doctor, you know, it could be a couple of days waiting. It'd be difficult to produce a cert on day one. So are you in the realms then of the flexibility and acquiescence of your employer?
You know, at the end of the day, once an employer is making payment for sick leave, they are, you know, committing to their obligations under the Act. But in order to avail of it, an employee must equally commit to their obligations. Would it be reasonable to wait, considering the fact that it might take you a couple of days to get a cert? Yes. I would say that there's a lot of facilities since COVID for virtual appointments with doctors, and that's something that, you know, employees may have to look at, but it will have to be set out in the policy, because at the end of the day, they will have to provide a cert if it's statutory sick pay. Remembering, Anthony, if a company already pays sick leave and it's more favorable, that requirement for a medical cert won't apply. Yeah,
okay. And is there a particular reason why the employer has to keep records for 4 years?
I suppose that the legislation, or all employment legislation, sets out requirements from a record retention perspective. and it's something to ensure that you can demonstrate your compliance from a legislative point of view. We know that the inspector from the WRC and the HSA have upped the amount of inspections that they're doing and arriving on site without notice to employers. And it's for the very purpose to ensure that as an employer, you are acting in a compliant manner with all your employees. So I'd imagine that that would be the reason for it. Remember, you're not going to retain information on personal health data. It's just about making payment for this amount of time on these dates for this employee who has this amount of service.
Okay. Just coming on to the state pension. It's such a wide-ranging presentation. But from January 2024, this legislation is going to apply. But does this legislation apply to staff who are already approaching retirement age? So somebody's going to go at 65, and under current legislation, correct me if I'm wrong, you do have an option as an employee to extend for 12 months.
Well, I
employer, and now we're saying you can go to 70. So if you're 65, let's say, or 64, coming to 65 in January 2024, and the new legislation kicks in, can you opt then to go to 70 to enhance your pension?
So look, I suppose we need to distinguish between the fact that this relates to the state pension scheme in terms of like the state pension, the contributions that you make as an employee, a PRSI employee. Currently, there is no statutory retirement age. But what the Code of Practice has done, which was developed by the Workplace Relations Commission, by the way, is effectively give an employee an opportunity to apply to extend their employment beyond their contractual retirement age. I would say 99% of employers would have that, a retirement clause in their contracts that could actually say 65 years of age. But because the state pension scheme extended to 66 some time ago, a lot of organizations are, more than happy for employees to stay beyond 65 up until 66 to reach a point where they can receive their state pension. But this is something that, relates solely to state pension. The Code of Practice is different. And that's where the legal requirements come in for an organization to objectively justify a refusal to allow an employee to stay beyond their contractual retirement age. And that's where employment equality can come in, and it can be quite costly to an organization if they can't demonstrate those justifications.
Okay.
Oh, sorry, a long-winded answer.
No, it's like I think the point I was making earlier, that it's an extremely complex area. It's extremely complex. If I go back to a number of years ago, and lots of us were dealing with on a sort of a partial HR basis. It's not the case today, because it's far too complex, and it's changing. It's evolving almost every couple of months. So Sarah, listen, thank you very much for that presentation. The update was absolutely terrific, and I'd like to thank Sarah and her colleagues at Adare HR Human Resource Management again for an excellent presentation. Tina is in the background there with Adare HR making it happen from their end, and David, my colleague, is in the background making it happen from our end. So thank you to both of them, and thank you for everybody for attending, and slán go fóill.